Good afternoon, everyone. My name is Jen Hicks. I'm the Director of Communications and Outreach with Maine Woodland Owners, a membership organization that provides support and advice to woodland owners in Maine. Today, we have our, I would say, biannual presentation, maybe a little bit more. We maybe do this 3 times a year where we have Karla Black and Tom Doak, our Deputy Executive Director and our Executive Director, present the latest from the legislature and other policy issues that they are working on this time of year. The legislature meets twice during a session. So we're in the 131st session, or legislature, sorry. This is the second session of the 131st legislature. So this is where a lot of the bills that weren't dealt with in the first session are being dealt with, where, you know, some curveballs are sent our way. And Karla and Tom spend a lot of time in the legislature, Karla mostly, and keeps an eye on the activity and speaks on behalf of woodland owners in Maine. So today's program is talking about what's been going on. We're about halfway through, we think, this session. And anything that people might have questions about, this is a great time to ask questions. And you may do that. I think, Karla, I didn't ask you this. Do you mind if people ask questions during your presentation?
Sure.
Would you like people to wait until the end of your presentation? What would
No, I'd say go ahead and we'll have a conversation with questions as we go.
Great. Hopefully everybody is a member of Maine Woodland Owners. If you're not, that's great that you're here with us. If you are not a member, we'd like for you to consider becoming a member by visiting our website, mainewoodlandowners.org. It's a great, this is one of the many things we offer our members and the general public, information and education. We also have a monthly newsletter. And in the March newsletter, if you've received it already, Karla provided an extensive overview as well of the legislature, but she wrote that about 2 weeks ago. So I'm sure there are new things since that article was out. So this is a kind of a follow-up to that. And she'll be writing until the legislature ends. She'll be writing articles about that and maybe beyond. So with all that said, I'm pleased to have Karla Black and Tom Doak here with us today. And I'm going to pass over the mic to Karla and to get things started. So thank you.
Great. Thanks, Jen. And welcome, everyone. It's nice to see you, even if I'm not seeing you. It's nice to have you here. Thank you for joining us on our legislative update. If you've been reading the newsletter, you know that things are getting busy here in Augusta. It is the second session, which is scheduled to be the short session for the legislature. Which means that they run from January until mid-June is their scheduled statutory adjournment date is April 17th. So they're coming up on deadlines that they're going to need to meet in order to try to achieve that goal. Although I've heard ruminations already that they are not anticipating making that. Whether that's true or not, I don't know. But they do tend to run over, so it wouldn't surprise me if they end up extending the session beyond that April 17th deadline. And again, if you followed our newsletters, you know that this session started off already on a busy note. They carried over a lot of bills from the last session that they didn't have a chance to finish. There were 483, I believe, bills that were carried over, which leaves them, you know, in a tough position starting off with that many bills. And I think they accepted another 100 on top of that for starting off the session. So we're working through them. The revisor's office is still printing bills. They're coming at a slower pace, but they're still printing them. So there's still more work to be done, and we're keeping an eye on what's coming ahead of us. But we have been busy and working on a lot of things. If you're reading the news, you'll know that the legislature is busy with a lot of different bills coming up with gun control rights, tribal sovereignty. The governor's budget is big right now, and those are all things that are in the works that are going to take up a lot of their time. But anyway, we'll give you an idea of what we've been working on, and Tom is gonna start us off by talking about LD 614, which is an act to provide a free antlerless deer permit to certain landowners who allow the public to hunt on their property. And this was a holdover bill from last session.
So the, those of you that may be familiar with in the past, landowners that kept their land open. Had 20 acres or more and kept their land open for hunting were eligible for any deer permit, free of charge to, and 2 years ago, the legislature, actually the department and through the legislature, changed the whole process on any deer permits and started the charge. And the logic was too many people were taking any deer permits, applying for any deer permits and not getting them or not paying, not using them. And also they added an opportunity for you to purchase more than one, so you could purchase more than. But when they did that, they also took out the part that said landowners would get were eligible for a free permit. And had to pay. Landowners still are given a priority on when they draw the number of permits, any deer permits, they limit the number per district. And when they're drawing who gets one, landowners are before everybody else, before the general public. But you still have to pay, and that was the issue though that some folks were objecting to. We said, well, you're taking something away from landowners here, and that is, we understand the logic here, but that's taking something away. So legislature came back and has considered a bill, and I think they voted on it. So they're going to still have a landowner have a issue, be able to have to pay for their permit. They still have the priority in a drawing for any deer permits. But they're also creating a fund specifically for landowners to deal with any wildlife, particularly deer-related impacts that are that landowners could then tap into to deal with some issues that wildlife are causing in woodland
Right.
owners.
Jesus.
Chip, I think you're not on mute. There, and so they're gonna create that, and as kind of a trade-off to the granting land or something. I expect that bill will pass, but believe it was voted on the committee, at least in concept last week. I don't think there was no opposition to it. So we're starting, which is kind of I think a good positive step, because now it's starting to create a fund that is actually funded by the any deer permit system to help landowners be able to apply for or get assistance directly from the IF&W department for things like fencing or gates or all kinds of other anything that might be related to a wildlife impact that landowners have. So I think it's a good start. It's and it does have a funding source, so I think that's probably a positive that came out of this bill. So that's where I think that one will end up.
Great. Any questions about that?
What is
Question.
I say a quick
See that,
question.
Tom?
What is the liability of a landowner if a hunter is injured? Sorry, I didn't see that. You want me to take questions now, Karla, or?
Yeah, why don't I'll read it to you if you want.
Yeah,
What
go
is-
ahead.
What is the liability of the landowner if a hunter is injured or injures others on the landowner's property?
We have a great landowner liability law in the state of Maine. It's intentionally protected landowners. The short version of that is you are not liable for the injuries caused by somebody or someone who's injured on your property unless you have done something that you know will harm them. You've done something, and the example I use is they're crossing some bridge you have, and you say, I'm tired of this, I'm gonna saw off halfway through the timbers, the next person that goes over is gonna go down through it. Well, then you've done something active that could harm somebody. You're not protected there, but you are protected otherwise. And whether someone is injured or someone else injures somebody on your property, the law is you are not liable. You can be sued. If you are sued, however, the court must, when you win, the court must order the person that sued you to pay for any legal expenses that you have. So there've been very, very, very few cases that ever have even been tried in the state of Maine. I think maybe less than 6. All of them have been resulted in in favor of the landowner, resulted in that. So it is a very good law, so that you are protected. Period. And that is intentional by the legislature.
And there's another comment that says, I understand that old wells are an exception to the landowner liability. The landowner is not protected.
They are not. Wells are not an exception. I think there's a perception that is, I mean, it may make sense for you to cover an old well, but you have no duty of care if someone's on your property. They fall down a hole, or they fall out of a tree, or they step in a well. You have no liability there. Period. You have not created something that you knew that likely would injure someone. So no, you are not liable in a well. Again, may make sense to cover it. I also tell people, if they're gonna put a cable across the gate, a cable across their road, it's probably a good idea to put something reflective on it, just so someone doesn't run into it, to make it visible. Just so you don't want somebody hurt on your property. So it's a good idea to do something if you think there's something there that might harm them, but you do not have that responsibility under law.
Next question is, how does the landowner notify hunters that hunting is or is not allowed on their property?
Maine, we are permissive trust. Oh, there's some good questions here. Maine is a permissive trespass state. The assumption is that unless the landowner has taken some step to notify the person that they're not allowed to hunt, the assumption is they are allowed. They don't have it's not a right, but they are allowed to. So the landowner must take steps, either through posting or purple paint, or telling someone verbally, or telling them in writing, somehow in conveying that they are not allowed there. Otherwise, there's an assumption that they are. Now, once told to leave, they must go, things like that, but they won't be convicted of trespass if you haven't taken some step to tell them. And then knowing whether they can go there, I mean, some people ask. There is one landowner, I don't think they're on, but actually puts up a sign that says hunters welcome, because they want to get the deer population down, so it's chewing on too many of their trees. So they actually put up a sign that said, here's our property, hunt. But that's and the question about purple paint is actually a alternative to those yellow no trespassing signs. You can actually put purple paint on a tree. It's a particular purple paint. And I'm trying to remember that it's a line that on the tree that's a certain length. I can't remember the exact details, but purple paint means access by permission only, essentially. Which means now most hunters, I can tell you, don't know that's what that means. But purple paint is an alternative to those yellow signs. And we can provide more information about that.
Great. I don't see any other questions, so we'll move on.
I wasn't expecting that many questions on that topic.
They're
Okay.
good questions.
Good question.
The next 2 bills we're going to talk about are both holdover bills from last session and deal with our current use taxation programs. And Tom's got the first one, which was LD 1648, an act to make changes to the farm and open space tax law.
And Karla's gonna handle the rest of these. I just happen to have the first 2 in numerical order here, so that I've been dealing with, so for quite some time, we've tried to make the open space, we've looked at the open space law to say it really needs to be revised. The open space law is an alternative to the tree growth tax law program. The tree growth tax law program, many of you are familiar with. But the open space program, basically, it allows you to, again, the land is taxed at its current value. And you don't have to have a management plan. You don't have to certify a management plan. You can have less than 10 acres. You don't have to have your primary purpose of growing commercial forest products. in it, but it's not quite as good a reduction in your taxes as tree growth. But there's a big disparity between open space and tree growth as far as valuation. And for almost every session of the legislature, there's a bill in on tree growth, and tree growth has been looked at and looked at and looked at and looked at almost every year. We've finally got it, so I think it's not an annual event at the legislature, but and we protected that law very, very well. But the open space program was initiated at the same time tree growth in the early 70s, and it hasn't been amended or really looked at much in 50 years. So we've been interested in trying to modernize it. So I worked with a group, a bunch of us have been working on that, and we have a bill, which I think it has, the final version of it is not yet out in front of the committee, but they did take a tentative vote at the taxation committee. And essentially what it would do to open space is it would make the valuation much closer to tree growth so that you could, so it wouldn't be this huge difference. What we found out, the average valuation in tree growth is per acre for which you apply the taxes to in Maine is somewhere between $300 and $400 an acre is the valuation. For typical land and tree growth, for typical land and open space, it's about $1,200. So there's a big difference there. So there's so the law that's pending and I'm pretty sure will pass, basically brings that much closer together. You still can't get as much as tree growth, but it will be much closer. In order to get significant advantages, reduction in taxes, you're given three options. One of them is to keep your land open for the public, and if you do, use a 25% reduction in your taxes. And then you have a choice of implementing a wildlife enhancement practice that's approved by the Inland Fisheries and Wildlife Department, or a carbon enhancement practice that's approved by the Agriculture, Conservation, and Forestry Committee. And if you do either of those practices and maintain them for 10 years, you're eligible for a 20% reduction in your taxes for either of those. So those reductions, keeping the land open for the public and in either a wildlife or a carbon project would bring you much closer to the valuation under tree growth. So I think these are good positive changes. There are people that are in tree growth that don't want to be in tree growth and are better off in open space or vice versa. And so I think the open space program would be much better utilized, frankly, by folks. And I'm pretty sure there's a couple other provisions that are in the law that affect those kind of the larger ownerships. But that will be the impact for that benefit. I think is a significant change in benefit, frankly, for small landowners, another choice for the current use taxation program. So I think it'll be a positive change for most landowners, to something to consider to enroll your land in. And I see questions on that.
I don't see any.
That's a bit more complicated. We'll be having more once the legislature enacts it or puts it through, and assuming it does get passed, we'll have a lot more detail about it. And those practices are not yet developed, so it would take some time before those practices are actually approved. But the bill talks about starting with practices that are already approved through the Natural Resource Conservation Service, which is the federal program that cost share programs are the landowners are eligible for cost share programs. And so there's already some standards in place. So starting with those as a basis for which practices would count. So again, it's a little bit complicated, but it's a good positive thing, I think, for woodland owners.
Great, thank you. I'm gonna move on to LD 1685, which is an act to increase acreage eligibility and change requirements for filing plans under the Maine tree growth tax law. This again is another holdover bill from last session, and it's one that gave us quite a bit of heartburn that we were following very closely. It proposed to amend the Maine tree growth tax law by changing the acreage eligibility from 10 acres to 25. And it proposed removing anyone who had less than 25 acres from the program. It also included a provision that would require landowners to file their forest management plans with the town, and the town would keep them supposedly confidential with the town. Unlike now where they can just request a copy and you have to provide it, but they return it to you once they're done looking at it. We testified in strong opposition to this bill, and we're very concerned about what was going to happen with it. In the interim, between sessions, Tom had an opportunity to have some conversations with the bill's sponsor and let her know of our concerns. And Tom, do you think this came from issues on the coast? Is that right?
Yeah, her issues were coming from an assessor who felt that there were people in the program that weren't following the rules. And there's been a lot of review of the tree growth tax law program, and the compliance rate is extremely high. But there are certainly people that are not in compliance, but the law allows the assessor to remove those folks. And our argument is that everything you need is already in place. You don't need to do this. And there are people that can manage parcels less than 25 acres. The minimum is 10. And in fact, we have parcels that our organization owns we have 7 or 8 parcels that are less than 25 acres, and they're all enrolled in tree growth. So, but it's usually a coastal issue that triggers the tree growth discussions.
And we cited back to a 2018 study that had been done by the University of Maine with a bunch of stakeholders, including Tom, I believe, that looked at the acreage issue and determined that no changes needed to be made. So we cited to that in our testimony. But again, I was saying, Tom had an opportunity to talk with the sponsor in the interim between the sessions. And when we got to the work session, the sponsor actually asked the committee to vote ought not to pass on the bill, which was really good news for us, that she was willing to have her bill die rather than move forward. So the committee did as she requested and voted ought not to pass, and it went through the procedural steps of going through the House and Senate, and the bill is now considered dead in the legislative files.
I have to give her credit. She listened to the arguments and was willing to get up and say, I don't want my bill to go forward any further. So it's good.
It was a good result for us on a bill that was very concerning. The next bill, I don't see any questions about that. The next bill I have on my list is LD 1823, an act to respect and protect the right to food. This is another holdover bill from last session, and if you're thinking the right to food sounds familiar, it does. You'll recall that there's a Sunday hunting lawsuit that's pending based on the constitutional amendment involving a right to food. So this is additional sort of carry on, I think, of the subject matter of the right to food and sovereignty issues. I think of this bill as the bill that tried to do too much. It has all of the sovereignty provisions in there, enabling the municipalities to enact more ordinances that allow local control over food sovereignty issues. But they went a little too far, in our opinion, and in the original bill, they included a definition of what they called traditional foodways, which in the bill was described to mean the cultural, social, and economic practices related to the production and consumption of food. And it went on to say that traditional foodways included hunting, fishing, gathering, and foraging. Our concern with that was that by allowing municipalities to enact ordinances involving traditional foodways, that left room open for municipalities to enact a Sunday hunting ordinance that would allow hunters to hunt on Sundays. And so we were very concerned about that. So we opposed the bill. It also included 2 definitions in the Department of Inland Fisheries and Wildlife and the Department of Marine Resources statutes of the word harvest. And it included the harvest definition also included hunting, gathering, fishing, and foraging. And you'll recall that the word harvest is what's directly at issue in the Sunday hunting lawsuit, whether harvest means hunting. So they were trying to get this word harvest into statutory definitions. The bill was tabled at the end of the session, and we thought the sponsor was agreeable to removing the provisions that we were finding objectionable. When the bill was brought back up recently, he offered an amendment that did remove the changes to the definition of traditional food waste. So he removed any concerns that the municipalities could enact Sunday hunting ordinances. But left in the bill was the two definitions of harvest, as well as creating a new right to hunt, a new right to harvest, a right to harvest wildlife through hunting, fishing, and trapping. And so we were very concerned about this as well. And we had discussions with the Department of Inland Fisheries and Wildlife, and they were concerned as well about including this in their statutes. There was an issue with the fact that it was not involved in their committees of jurisdiction for Department of Marine Resources and Inland Fisheries and Wildlife, that it was instead before the Agriculture, Conservation, and Forestry Committee. We also had concerns of what the impact of this would be on landowners. A lot of those activities, hunting, gathering, fishing, and foraging, occur on private property. So what would creating a right to hunt or right to harvest, what would that do to private landowners? The IFNW did a lot of outreach to the sponsor of the bill, and he was amenable to their concerns. And so he removed both definitions of harvest as well as the right to hunt, the right to harvest. So that removed our concerns with that bill. At least our particular concerns that would impact landowners. That bill was heard in committee yesterday at the work session, and there was a divided report. The majority report was ought to pass as amended, and the minority report was ought not to pass. So there's still more to be seen from what will happen with this bill. There's a possibility if the remaining provisions on food sovereignty go too far, there's a possibility the governor might be willing to veto the bill, but we don't know that for certain yet. But at least our provisions from that have been removed, eliminating our concerns with it. Anything I missed on that one, Tom?
No, I think it just shows you the last 2 or 3 bills we've talked about. The importance of us being able to intercede early on in these kind of things makes a difference. We were able to, Karla and others, and Karla and I, particularly Karla, have been able to, push some of the things, the concerns that we have. We've been able to work through a lot of these and get these things out of these bills, so they no longer impact, landowners and or impact them in a negative way, and that has been really important. And so much of the activity occurs not in the hearing room or not in the work session, but actually in the hallways and talking to the sponsors and the departments, and that's really where a lot of these issues frankly get settled. I think people don't always appreciate the fact that you think a lot of it happens right there in a room when they're all sitting there, but that's really not what happens. And I will say we've had good luck, I think, with expressing the views that when we object, and we've had a good chance to be heard. So that's the importance of being involved there early on.
Yeah, it's definitely a good result on that one as well. The next bill I have is LD 2063, an act to clarify the laws governing disclosure of wood processing data. This was a bill that was brought forward by the Maine Forest Service this session, so this was a new bill. It authorizes the Maine Forest Service to share certain confidential information that they collect from wood processors in the state with the U.S. Department of Agriculture, the Forest Service, U.S. Forest Service, provided that they enter into a confidentiality agreement with that agency. And it further limits the disclosure of that information to summary reports that use aggregate data. We provided testimony in support of this bill, and it went through committee very quickly and easily. It made its way through the House and Senate without any problem, and the bill was signed into law by the governor. The next bill I have is LD 2101. Unless there were any questions on that, I don't see any. 2101 is an act to strengthen shoreland zoning enforcement. You may have read about this in our most recent newsletter article. This bill authorized a municipality to restrict the issuance of or suspend or revoke any municipally issued permit to the owner of real estate who violates a shoreland zoning ordinance. It also authorizes a municipality to claim a lien on that property for all costs incurred by the municipality, including any unpaid penalties and attorney's fees. It provides a similar authority to the Land Use Planning Commission. And I testified in opposition to that bill. Our concerns were not for lack of interest in providing municipalities with enforcement options for shoreland zoning. We certainly don't condone shoreland zoning violations. But our concerns were with the broadness of the bill and the fact that the municipality could issue a suspension or revocation of a permit on real estate that was unrelated to the violation on which the violation occurred, as well as imposing a lien on the property. The Maine Forest Service also testified in opposition to this bill. We were the only two organizations that opposed the bill. There was a lot in support of it. Apparently there's a situation in Raymond that has maybe prompted the bill to be brought forward, where a landowner has cleared in front of his property on Sebago Lake and has created quite a situation there. And they've been trying to collect from him for some time, and he's blaming the contractor, and the contractor's in bankruptcy, and it's quite a situation. So I think they were looking for more enforcement opportunity, and is what prompted this bill. At the work session on the bill, an amendment was offered that would require a municipality to send a violation notice to the violator via certified mail and give them 10 days to remove, abate, or otherwise correct the violation. So that gives them some notice that they didn't have in the prior bill. It gives them opportunity to correct the violation before anything happens to their property. If the violation is not corrected, then the municipality can again restrict the issuance of, suspend, or revoke a permit by the municipality, but on the real estate on which the violation occurred. So it's limited. They can't go out and restrict or issue the issuance of a permit on a wholly unrelated parcel of land that you happen to own in the same municipality. They can also file a civil action against the owner to recover unpaid penalties and the costs, including attorney's fees. And if the municipality is the prevailing party in that litigation that they file, they can then file a lien against the real estate on which the violation exists for all costs awarded by the court. So this is definitely a more balanced approach and provides, again, some notice and opportunity to correct the violation, as well as limiting the potential repercussions to the property on which the violation occurred. 8 members of the committee supported the amendment. 1 was opposed, and there were 4 members absent. So there will be a divided report, but with that strong showing, with 8 members in support of it, it looks like it will potentially go through. So that was, again, Tom's, pointing out that we have an impact. That was one in particular where I don't, if we hadn't raised our objections, I think the committee would have passed it as it was. So I think that, having our objections known, as well as the Maine Forest Service, they did a lot of work on this as well. having those objections out there and known to the committee really created an impact that turned this bill around into something that we no longer oppose. And will provide municipalities more enforcement tools. So I think that it ends up in the right situation. Any questions? I don't see any questions on that. The next bill I have is LD 2191, an act to provide relief to small businesses affected by severe weather-related events. This bill establishes the Small Business Weather Emergency Relief Program, and it creates a $50 million appropriation from the general fund to fund the program. And it would provide relief payments to small businesses that have been affected by severe weather-related events. It doesn't limit it to the January and December events that we had, but that's certainly the precipitating reason for the bill. We testified in support of this bill. And we advocated at the public hearing that owners of woodlands should be included under the definition of small business. Our position was that woodland owners are often in tree growth programs, and therefore they're managing their properties for commercial products such as timber and things like maple syrup and Christmas trees and all things like that that can be considered under the commercial products and the tree growth tax law program. And we provided information about the loss. You may have recalled getting a survey from us that Jen sent out a couple of times, the survey about damage that was caused. We provided information that our members had experienced significant damage to their roads, their culverts, their bridges, and their designated ATV and snowmobile trails. And so we encourage the committee to consider including woodland owners in this definition. There is no definition currently in the bill that is presented. It leaves it up to the Department of Economic and Community Development to do rulemaking to define the parameters of the program. But the committee seemed very interested in what by the other folks that testified and the questions they were asking. It wouldn't surprise me if they tried to dig in and maybe create their own definition of what is included in a small business. The work session on this bill is actually tomorrow, and I will be attending that to see where things go and what the committee is interested in terms of moving this bill forward. And those are all of the bills that I have on my list. Are there others, Tom, that you can think of?
Well, I was gonna talk about the rulemaking.
Oh, right, yeah.
At some point. So there is we are involved in a rulemaking hearing next week at, before the DEP board, the Department of Environmental Protection Board. And the rulemaking is actually about solar farm. It's about protected habitats related to solar farms, transmission lines, and wind sites. But there's a new wrinkle. We're not involved in any of those projects, but there's a new wrinkle in what would become a protected or a habitat that would have to be considered needing protection in that rule. And they're called large habitat blocks, and that means that they're defined as 250 acres of forested land, contiguous forest land in southern Maine, 500 acres within central Maine, and then the rest of the state, it would be within a certain distance of a paved road. So almost all the unorganized territory. And it basically would say that if you're going to do one of those projects, like a solar wind or transmission line, that you're going to have to mitigate. Those are protected zones that need mitigation for those activities within any of those habitat blocks.
So it's not really an issue for us on those activities. But what if it become, and that's about, the best guess is that's about 14 million acres of the state of Maine would be would be in this kind of protected status for those activities. So our issue is, well, if they're protected for those three activities, again, wind, solar, and transmission lines, why wouldn't they then become protected for any other type of activity? So it would affect basically an awful lot of woodland, where if you wanted to do something to change it from woodland or something, or then you'd have to mitigate the impacts. And so we think that's and it basically says all large blocks of land are automatically important and all kind of special. And I think we all know that there's land that just kind of, some of this land holds the earth together. And so we have concerns about the scope of what they're talking about here on the rules. And there was a working group put together before this rule was put out. But it didn't involve any of the landowners. It involved farmers. It involved wind power, solar power, wildlife interests, but no. And it started out as an agricultural, protecting important agricultural lands, but kind of morphed into this forestry issue. But the working group included no woodland owners representatives on when the rule was developed. So we are raising concerns next week about its impact, and saying that you really ought to go back to the working group, create a working group that expands, involves woodland owners, and before you go any further. So that one has potential to have a lot of less big long-term impacts on woodland owners, not the wind, because it's wind power, solar, and transmission lines. It's not immediate, but we see it as potential kind of a new regulated habitat almost, which would be about 14 million acres in the state of Maine. And so we think that's a huge overreach here, and not the intent of the legislature to regulate those kind of habitats. So we'll let you know how that turns out. That's a rulemaking hearing before the DEP, and then it would also have to go to the legislature, and it would require a passing through the legislature as well. So we're a long way from anything happening on that one, but next week is the hearing.
And I just realized that I talked about the Sunday hunting lawsuit, but I didn't actually give an update on it. And I can do that, but Cy, in a minute, Cy has a comment. This is NIMBY against climate change addressing infrastructure.
Uh,
I think his comment was addressed to your.
I'm not sure, Cy, exactly what you mean by that. You want to unmute and give it a little more detail?
Sure. This is the same thing we're seeing with solar farms and other places. People don't want to see it physically. It's changing something. They're developing all kinds of bizarre reasons not to do it. And I see this is the same thing. And it really worries me, because we got to address this stuff, and we're getting blocked by folks like this from addressing it.
Because the interesting things about solar farms is we kind of know where they gotta go, because they have to go near power lines. You can't put them in the middle of nowhere, because they gotta hook to the grid. So there are limited places you can actually put these things. So.
Near us, the town of Trenton squashed a solar farm just because it was ugly, and they came up with all these reasons, and the town squashed it.
Right.
So it really bothers me to have this kind of response to efforts in infrastructure that are really trying to address climate change, and they're being stifled.
We'll we'll keep everybody tuned in on what happens on that one. So that's not legislation yet. It will be next legislative session, right? I would have to, it comes back next session. It would have to come back to the legislature. I think what we're asking is that you stop this process and go back to the drawing board and involve woodland owners before you start doing this kind of stuff. So we'll see what happens there.
Great. So the Sunday hunting lawsuit update is really a non-update. There's no word yet. We're not so patiently waiting for the word to come down from the Supreme Court on their decision on the lawsuit. I think we're anticipating that could be any day now, but it was not today. They released some decisions today, and I looked anxiously to see if it was included among them, and it was not. So we will keep an eye on that, and certainly we'll let you know when we hear what the result of that lawsuit is, and hopefully it will uphold the rights of the department to, institute the Sunday hunting ban.
If we have to guess, Karla, would you say the length of delay means they may be trying to? Because we thought one option would they send it back to the lower court and say, give us more. The lower court just basically rejected it. And we think the Maine Supreme Court may have wanted this lower court to say, well, why did you reject it? Right, essentially. And they could have done that very quickly. The fact that they haven't leads us to believe that they're probably they may very well rule on it and are developing the justification for their ruling. And we still don't believe that they will rule in favor of the lawsuit.
Yeah, that would be my best guess if I had to make one, but I don't do those kind of things.
I know, I did that for you, so.
That's our hope, anyway.
That's right. Are there any other questions? I know we went through it kind of fast and we still have a few minutes. If there are any questions about any of the bills or the legislature generally, or. I don't see any.
Any other hunting issues that anybody wanted to, I got like 4 questions right off the bat on hunting, so if there's any, while I'm here, if there's a hunting issue or access issue that you wanna bring up, feel free to throw that up too.
Is there, do you think there's gonna be any issue that you're gonna need our members' voices to speak out on at this point?
I don't see any big issues coming down the road. There was one additional current use taxation bill that was listed among those that were accepted for inclusion this session, but we haven't seen that yet, and it was related to the farm and open space regarding the recapture penalty imposed. But that one hasn't been printed yet, so I'm not sure if the bill that's being worked on sort of took care of the concerns that it was going to address, or if it's just late in the process, but that's one that's out there that is potential.
The right now, I'd say we're in pretty good shape. I mean, we try to make it clear to our members, when we ask you for your help, that means we are very concerned about where this is going, and we really need you to weigh in. So we try not to get, cry wolf all the time. It's still very possible that, there are bills that we haven't seen yet, as Karla said, or, you can still put bills in through, if you get a majority of the leadership of the legislature to put a bill in, and it would not be surprising to me that we see a bill on something last minute. Some of these legislators are term limited, and this is their last shot. So I wouldn't be surprised to see something that might not be a very good thing for us. The other thing that is pending, as Karla mentioned early on, is all the appropriation bills that are hanging around. There is a bill that would create this advisory board to the Forest Service to direct the activities of the Forest Service that we have opposed, and that's sitting on the appropriations table. If that were to get funded, it passed but needs to be funded. If that were to be funded, the governor vetoed it the last time. We would expect the governor to veto it again. We might ask our members in that case to contact the legislature and support the veto, or something like that. I could see happening as well.
We don't usually have that issue about asking to help support a veto. But that's something that I could see on that particular bill. We think that bill is not a very good thing at all, the way it's structured, and we think that that shouldn't become law, and so that might be one that we would ask for help on.
There's a couple comments, but one more question is, once we do hear from the Supreme Court about the ruling with the Sunday hunting, if it's not the way we are hoping it's going to rule or come out, what are next steps? What will we do as an organization? Have we thought about that?
Yeah, I think if you're gonna direct it there, and I don't want to scare anybody, because I don't think there's any chance, well, I hate to say this, I'm on tape. I don't think it's very, very likely at all that they're gonna say this means that you can hunt on Sunday automatically. I think nobody really thinks that's gonna, but if that were to happen. I think our next move would be put a bill in that requires landowner permission for all hunting. I think that would be the next step, that's the logical reaction. I think that, okay, if you're gonna have hunting 7 days a week, then you have to have permission 7 days a week, period. I think that's likely the scenario. I see a couple of questions about like a game camera found, yeah. Unfortunately, game cameras, there are 4 times you need permission from a landowner. Game cameras, if you cannot put up a game camera on somebody's land and leave it, a tree stand, trapping, or riding an ATV. I can tell you the lands that we own, we found, I don't know how many tree stands we found and game cameras. You have a couple options if you find a game camera. If you are a tree stand, you can keep it. If you want, it's left on your property and you can keep it. You can also notify a game warden. They're supposed to be labeled, but my experience, I've not found one yet with anybody's name on it. They're supposed, by law, they have to be labeled the name of the owner, tree stands and game cameras. So you could keep it. You can also contact the game warden. The game warden will come out. Probably put a camera on it so that they find out who goes to see the camera, those kind of things, or they'll look at the camera and see what's on it, see if there's some evidence. But same thing with tree stands. We've gotten to the point where we basically take them and give them away to anybody that wants one. Sometimes it's the logger. Take that down. If you want to take it down, you can take it home with you. And that's what we've been doing. But the warden service will, and they have helped us on a couple of the tree stands where they have well, actually a couple of times they've walked in and found the person in the tree stand. And they've had a nice conversation with the person, and the tree stand does go out the door, go thieves. So if you need help with that, George, I see that note from you. If you need help, we can help you find the right game warden to help you. Or the land relations warden can help you. We can get you that information. And then size comment just about many landowners do not know that they have to post all the way around. That's true. You know, the test really is, was it reasonable that that person knew that they weren't allowed? That's really kind of the test. You don't have to post all the way around. If you have evidence the person walked right by the sign and it was right there in front of them and they walked by it. And they should have seen it, or they drove by it, or you got a camera picture of them walking past the no trespassing sign. That's enough. But the reason you would post all the way around is that the argument they could say, well, I went in on the property here and there was no sign, so I didn't have any idea it was. Or the trick is a lot of times someone will pull the sign down and then say, well, there was no sign. But yes, to get a conviction, you really have to have something that indicates that they did
fact, they knew, or they reasonably should have known. Now, once they're told, if you find them on the property, or particularly a law enforcement officer, if a game warden finds somebody on the property and says, you're not allowed here, that's all you need at that point. If they come back after that point, that's actually criminal trespass. And that, you know, when a law enforcement officer tells them. So you're having a problem with somebody, it's often good to get a game warden to tell them not to come back. And that will hold up, in a court. No question, if they are back. So. I don't see any other questions.
I don't see any either. I think that brings us to the end.
We'll keep updating our legislative action webpage with, as we get updated ourselves. So keep, visiting our website. You'll see, if you go to mainewoodlandowners.org, you'll see legislative, action, and you can click on that page. And that's also where you can find the Sunday hunting information. So, that can arm you with all the arguments, for keeping Sunday hunting free and why it's good for hunting overall and good for access to private land. Please call our office or email us if you have more questions. This is a really important part of what we do, and making sure that we are supporting landowners and that they understand what's happening in the legislature. So have a great rest of your day. Thank you for joining us, and we'll see you again at one of our next either online or in-person events. Check our events page as well on our website. So hopefully everyone has a great rest of your day. Thank you very much.
Thank you all.
Bye.
See ya.